Good morning. It is April 1st in the Judiciary, and we are taking up page 98. We are starting off with polychrome on the screen.
Good morning. Thank you so much for having me. I appreciate being here this morning, and I hope you can hear me okay. Sorry I couldn't be there in person this morning. I just want to say thank you so much for having me testify in support of this legislation. My name is Polly Crozier. I'm the Director of Family Advocacy at GLBTQ Legal Advocates and Defenders. And I'm also here as an adoption lawyer and family lawyer by training as well. As you all probably know, GLAD Law has had the pleasure of collaborating with Vermonters over many decades to better protect children and families. Personally, I've been a part of that work since 2016 in my work on the Vermont Parentage Act. And I would just say the Vermont Parentage Act has really served as a model for other New England states because honestly, it is very clear and very well organized, and it has really been a tremendous influence throughout the region. And I think that H98 is really a continuation of Vermont's work to increase stability and security for children. I'm going to walk a little bit about what this bill does, why it's important. I know Attorney Childs has done that as well for the committee, but just from the perspective of an advocate. But I just want to start out by saying I think we feel like this bill is simple, but incredibly important and very much wanted, and appreciate your consideration. So this bill really came out of work actually from last session, right? There was some tweaks to the Vermont Parentage Act. And one of the things that came up was families in Vermont were feeling like they want the option of adoption as well, and that they need, kind of to reduce uncertainty and to increase the ease of getting adoption decrees. So this is what that bill does, right? It essentially adds to the Vermont Adoption Code a confirmatory adoption provision so that families who are seeking adoption to confirm parentage rather than establish parentage have an easier access to an adoption decree. It was drafted to apply to children born through assisted reproduction to parents who are honestly already parents under Vermont law, but who need that decree for additional protection no matter where they may travel or move. This bill aims to provide a more streamlined process, for example, so folks do not have to wait, go through the waiting period, the home study process. And I know that Attorney York will provide more input on kind of how this is happening on the ground now in Vermont. And Attorney Hughes, who, so I'm sorry he can't be here today, but did provide written testimony for the committee. Okay, so as you know, just to put a little bit of context, adoption is a really important path to parentage. Many adoptions involve adopting a child who is not known to your family and is coming from another family. And so as such, the adoption code has really appropriate requirements to make sure that that adoption is in that child's best interest, including a home study, notice to birth parents, a waiting period to make sure the home is a good fit, all of those kind of protective measures. That's a traditional adoption that establishes a new relationship. So for children of parents children born through assisted reproduction, using donor gametes like many LGBTQ families, which is why my organization has a particular commitment to this issue. An adoption is more of a tool to confirm a relationship that already exists. It's really about security and protecting the parent-child relationship so their relationship can't be undone by states or jurisdictions that might discriminate against them. Because an adoption decree gets full faith and credit, exacting in every state. There's in fact a US Supreme Court case, VL versus EL, that specifically provides that in the context of actually an LGBTQ adoption. So that's why many people in the community feel like adoption is kind of their gold standard protection for their children, which again is to hit back why this bill feels really important. I think people in the LGBTQ community and beyond are feeling just a lot of uncertainty, a lot of fear around just the general instability in the country and fear for their relationships, fear about the stability of marriage equality, and are looking for tools to add that they can do to add protection. We have a legal intake line. We have heard from hundreds of families, done a lot of education, and this is what we hear from people. They want easier paths to protecting their families. The Vermont parentage law right now, it's excellent. We're grateful for all the work the legislature has done to clearly lay out the paths to parentage in Vermont. This bill adds an additional option by saying having this confirmatory provision to allow for people to get adoption decrees in a more streamlined manner. I will share an example of why this feels particularly important because there are actually cases in other states where children born into marriages through assisted reproduction, their non-birth parent has been stripped of their legal parentage because they didn't have an adoption. Now, they shouldn't have had to have an adoption. They should have been treated equally like other families, but this is not what has happened. In Oklahoma, for example, it happened also in Idaho. There was a case recently in Pennsylvania because they have a strange marital presumption. The Supreme Court of Pennsylvania fixed the problem, secured the child, but the goal is to avoid expensive litigation, to avoid uncertainty, and allow people to get an adoption decree if they want it soon after their child's birth. So I think this is very much a common sense bill that adds another tool for families facing discrimination and bias, particularly in other states. A number of states have added this type of provision to their law. We are now up to 9 states that have a specific confirmatory adoption provision. New Mexico just passed and signed their bill into law just a few weeks ago. Thank you very much for considering this bill. We think it's an incredibly important support for families in Vermont. And I'm happy to answer any questions now or throughout the legislative process.
Thank you. I did just have one question. I'm just looking at some of my notes here. I'm looking at page 3, lines 16 through 17. I agree with this bill in general, so I'm just wondering what your thoughts are on that, on not requiring the verification, the child's not on the registry for missing children.
Yeah, it's a great question. Thank you for asking it. And I will just say, I have done a co-parent adoption of my own children. I actually had to do the federal missing children's report. And it's funny because the one person in my state that did it was on vacation for 6 weeks, held up all of these adoptions. It was unfortunate, but I think that should be it's appropriate to waive that, because in these situations, these parents are coming to court with a certified copy of the child's birth certificate and with obviously affidavits and information linking them to their child. So I think that it's clear to the court that these are already the parents of this child, that it is a known child. And also to the extent that there is some worry or some hint of impropriety, which I can't really imagine, the court, of course, does maintain the discretion to say, you know what, there's good cause in this particular instance to still require X, Y, and Z.
So is checking that registry a lot more than just putting a name into a computer? Is it a long-winded process?
Well, I'm actually not sure. I just know it got delayed in my state. I will say for people who are already the parents of their children, it feels very insulting and unnecessary because, again, they have all of their appropriate documentation that shows this was a child to whom they are legally connected and who, they have a right to direct their child's upbringing.
I totally hear where you're coming from with that. I mean, I'm just trying to think of all the different possible angles. But yeah. The only thing that I'm thinking of is an instance in which there is, I don't know, maybe a messy divorce and, there's a custody battle of some sort. Of family law, my area of expertise, but I just.
That's a
little bit more digging on that particular piece, just to make sure that I get they're showing up with certified documents and affidavits and so on, but people.
I do want to assure you, absolutely, anyone who is already, I'm a family lawyer by training. I've unfortunately dealt with a lot of contested issues. I know how terrible people can act in those vulnerable moments. I do very much think that there is no way a Vermont court is going to entertain an adoption if, one of the legal parents is not noticed or participating in that proceeding, right? That there is, and in fact, if there's anyone who should be due notice and isn't before the court, certainly the court is going to pull those people in. And I don't think nothing about this bill changes that practice.
Okay.
I think you're absolutely right. No one wants to use adoption to weaponize in a custody proceeding. But that's really not that situation. And from an adoption perspective, like really, it's very rare for people to do contested adoptions. I mean, outside of, when, for example, a step parent adoption or whatnot. And in any event, I don't think that it's a great, I'm happy to look a little bit more into what that verification process looks like on the ground level. But again, I do think that it's a slightly different issue from the noticing parents, which absolutely agree parents should be noticed.
Thank you. Committee, any questions or comments? Okay, great. Thank you for your time. Appreciate it.
Thank you so much.
Next up, we have Megan Ward. Yep.
Right. Thank you for having me here today. My name is Meg York. I use she, her pronouns, and I am the director of LGBTQ plus family law and policy for Family Equality, a national LGBTQ plus advocacy organization protecting LGBTQ families. Prior to joining Family Equality, I was the assistant director of the LGBTQ plus family law program and family law clinic at Vermont Law and Graduate School. And there we helped LGBTQ plus Vermonters access their rights and protections and help them through family law cases. Prior to that, I also was engaged in some family law private practice here in Vermont and worked in the child abuse and neglect docket as an attorney here in Vermont as well. I'm also a mom here through assisted reproduction. I have one child who is not genetically related to me and two children who are, and I've been able to access the protections that Vermont offers. And I share all of these different aspects about my background because each of them informs my understanding of this bill and my understanding of why it's so important. On the national level, I feel like I can echo a lot of what Polly said, right? Where we see time and time again that when a parent and a child do not share a genetic connection, there are increased vulnerability for that parent, but also for that child. And so we want to make sure that these families created through assisted reproduction, families where one or both parents may or may not share a genetic connection to their child, have appropriate access to legal security. And when I say legal security, I mean a court order. Because here in Vermont, as you've heard, we created great paths to legal security with our Vermont Parentage Act. I know Michelle Childs has also walked you through the Vermont Parentage Act and the protections that it provides. And so here in Vermont, when you have a child through assisted reproduction, you're automatically the parent of that child. But we also know that there are other states that don't necessarily recognize that the same way. And because of that, even for Vermonters, that leave Vermont families vulnerable, right? When they travel, if they move, things along those lines. We heard about the Oklahoma case, right? Stripping a non-genetic parent who was married to their spouse of their parentage and instead instating it in a sperm donor. So there are a lot of vulnerabilities that families created through assisted reproduction face. You know, I'm here on behalf of an LGBTQ organization, so I think it's especially important for LGBTQ families, but really it's important for all families or any family who uses assisted reproduction to make sure that there is a streamlined path to obtain a court order that provides them with the maximum level of security. Why do we need that in marriage equality? For a few different reasons, right? Some of the families who use assisted reproduction aren't married. That doesn't mean that they're not parents and shouldn't be recognized as such. The other thing is we've seen efforts, as you know, there are many states who are looking to undermine marriage equality. And so we want to make sure that no matter what happens, no matter what the future holds, these families have access to the legal protection that an adoption order provides. I know it sounds strange, right? Like, why adopt your own child? Why not just get a judgment of parentage or do something along those lines? Well, we know that it's strange, and we also know that it is recognized, right? An adoption order is not only portable, other states know what adoption means, But the Supreme Court has told them what adoption means. You heard Holly reference the BL versus EL case, where a family, if they know that if they get that adoption order, even if somewhere down the line they're in a state that wouldn't otherwise issue a similar order, the state has to respect it. And that is a great level of protection and a great level of security for these families. It's also why this is called confirmatory adoption. The idea of adoption is typically this idea of establishing parentage in somebody that's otherwise a legal stranger, right? We think about that when you're bringing a child into your home through maybe like a placement adoption or adopting through the child welfare system or DCF. But here, when we're talking about, or even step-parent adoption, right? You have a new parent come in and you move through the adoption process that way. This situation is different. And the reason we're calling it confirmatory is because what we're doing is we're confirming the parentage that already exists under Vermont law. But it is an option that people are looking for to have that confirmation, to have that court order. So, we've talked about the great strides that we made in Vermont with the updated Parentage Act that we put into place in 2018. We were the second state in the country to really update our laws, which was fantastic. And this confirmatory adoption law, in some ways, is a continuation of that, but in other ways is also a much needed update to our adoption laws, which have been left untouched for quite a while in this regard. So we have in Vermont, we have step-parent adoption that's under Title 15A in our statutes. And in that regard, a step-parent can adopt the child of their spouse with leaving the parental rights of that spouse intact. In 1993, there was a case called In Re BLVB, where there was a same-sex couple, of course, pre-marriage equality, so they couldn't do step-parent adoption because they couldn't be married, right? And the court looked at this case and said, the intention is the same. We need to protect this child. It is really important for the child to have access to the parents who are raising that child and who intended to bring that child in together. And so in 1993, the Vermont Supreme Court said this is going to extend even to people who are not married, right, or who are in a same-sex relationship. And then in 1995-96, the Vermont legislature updated the Vermont Parentage or the Vermont Adoption Act to include or partner in the adoption statutes. Now, partner was never defined, but we've taken it to mean somebody who's not married, but a very similar type of a situation to a step-parent adoption. And that's really kind of the mechanism through which LGBTQ people or people who've used assisted reproduction are securing their rights through adoption here in Vermont. You'll hear some people call it the second parent adoption process, but here in Vermont, we call it step-parent or partner adoption. Now, again, when we talk about ease of access to court judgments, in some ways, yes, we have that path if they want to do a step-parent or second-parent adoption, but it is a path that wasn't ever designed for them, right? It was a path that was designed for the idea, again, of establishing legal parentage. And because of that, it's an arduous, complicated process that doesn't fit the families that we're talking about. And so what happens when the process is complicated or doesn't fit the families that we're talking about or the families' needs? What happens is you have some people do it. You have some people who are deterred from doing it because they're confused by it or feel like maybe they can't afford it or maybe they don't know what's asked of them. And then you have the people that know that they want it and they do it and they jump through all the hoops, but the process is so long. And so there's this wait time, this increased vulnerability time where they're waiting between filing for the petition and getting the order while we're doing all of these things that are unnecessary for the type of family they are and for the structure of family that they're in. And in all of those cases, it increases the vulnerability of the kids and it increases the vulnerability of the family. And unnecessarily so, because these are people who are parenting and who are already parents. Now, you might think, why do we need this confirmatory adoption if they can do it just as fast through judgment of parentage or our parentage judgments? Does that mean the parentage judgments aren't as good? No, it doesn't. The parentage judgments are fantastic. They are strong and they are good protections from the law. And yet some people still want adoption. Why do they want adoption? Because this has been a tried and true method for securing legal parentage for LGBTQ plus people or families created through assisted reproduction for decades. And so there are some states that offer judgments of parentage. There are other states that do not. Does that mean that they should not honor a judgment of parentage? No, they should, right? They should under the full faith and credit principles of the Constitution. But if you're in an emergency situation where this is coming up, do we want a family to feel like they've got to explain how to do this? Or do we want to make sure that the families have the option to say, I want to pursue a judgment of parentage, it's the streamlined option. I want to pursue an adoption, it's also a streamlined path, right? And it feels to them potentially more portable, right? Whether or not, and it is portable, right? Both should be portable, but it might feel like an option that these families want. It's an option that these families are asking for. So this bill, in some ways, it's so simple because we're not expanding the law. We're not expanding the law, right? This bill applies to people who are already recognized as legal parents in Vermont. And what we are doing is saying, here we have an option. We're providing these folks an option to secure what they know to be true, what our state recognizes to be true, what their kids know to be true, that they are the legal parents of their children, and that is going to be secure no matter where they go, no matter where they travel, no matter what happens down the line. What's happening here in Vermont, like I told you a little bit, we've got, because in adoption, the statute was not designed for these families in mind, we've got a lot of the people who are feeling confused on how to access it. The judges sometimes are trying to navigate these processes of, what do we accept, what do we not accept? Do we waive the home study? Do we ask for something instead of the home study? Because now how do I fulfill the statutory requirements for these families? And so not only is this helpful for the families and for the children, but it's also helpful for the courts, right? We know that we have a backlog here in Vermont in all of the divisions, the court divisions. And so when we're talking about the probate division and the time that the judges need to spend reviewing these petitions, the time that they need to spend in court with these families, having a streamlined process for people who are already parents just helps with judicial economy, right? Because the judges can say, yep, this is all right, this is all accurate, and not have to hold a hearing, right? They don't have to go through all of these processes. And yet, as Attorney Croder mentioned, if there's any whiff of, I'm not sure about this situation, they have the option to bring to have the remote hearing, to bring the family in to talk, to figure out what's going on, and to have that discretion to really look into things or to ask for more information. So, at the end of the day, by this bill would streamline the process, which means that more Vermont kids would be protected. And that's really the goal here, right? We want to protect the kids. We want to protect the families. It's a conclusion, 9 other states have done this. Vermont would be the 10th state. We're not going out on a limb here, but we are, again, coming in towards the beginning of these processes, showing that Vermont has always been ahead of these issues because we care about protecting the kids and families no matter how they come into being. Again, it's for folks who are already parents. And then it allows the courts to maintain that judicial discretion. So really through this act, Vermont would address this important need to allow parents to secure their parent-child relationships through adoption in this really efficient and validating process, right? We're not making these parents have already jumped through so many hoops to become parents by the time they've gone through an assisted reproduction process that now we're not kind of adding more to these families by asking them to, go through fingerprinting and go through all these background checks. We are providing these families with dignity and a streamlined process that validates who they are. So it's really, it's a common sense bill. It's really narrow in scope. It's going to apply to a small portion of our population, but in a portion that really needs it and has been asking for it. So that's why we're strongly supportive of this bill. And I'm, of course, happy to answer any questions as well, either now or throughout the process.
Thank you. Committee, any other questions? Senator Brooks.
Do have a question, and it's around cost. So one of the things I've heard from members of my community who have gone through this sort of current process is that there's a lot of cost associated with that, which feels a little bit to be unjust that we're charging people to prove that they're parents. Does this streamlined process do anything to help with the cost under our current system?
Absolutely. I can list a few different ways that it would help with cost. So one thing is through our current process, there are multiple costs. There's the cost of the filing fee. There's the cost of the background check. There's the cost of the fingerprinting. There's the cost of obtaining various forms of certified copies of things. Now, we still have some certified copies required here under this bill as well. But when we look at all of those costs, this bill would eliminate several of them. First of all, it eliminates the complicated aspect of the process, which means that more people would be able to access it without necessarily having to hire legal assistance to do so. Because we're eliminating the background checks and the fingerprinting and all of those aspects, that eliminates those costs as well. It does not eliminate the cost of the filing fee, but Vermont does offer a filing fee waiver for folks who struggle to pay the filing fee. So there is a possibility of being able to do this at an extremely reduced cost, potentially even no cost to the people who are filing for the protection.
I think you got to one of the questions I had, which was the differentiation between a judgment of adoption versus a judgment of parentage, and how adoption is more affordable. And can you just provide a bit more information on that? Because in my mind, I'm looking at the underlying mechanism of this is using full faith and credit. If a family is going to another state, why wouldn't why wouldn't a judgment of parentage be sufficient? And so if you just have more information on that, that would be helpful.
Sure. So it is Family Equality's position that a judgment of parentage is sufficient, that it should be afforded the same full faith and credit protections. When I talk about portability, I talk about portability in the sense of people's understanding of legal terminology, people's understanding of the law. There is, because of the longevity of adoption as a mechanism for establishing or confirming parentage, particularly for same-sex couples, the portability aspect is really just that somebody in another state is going to immediately understand what that means in a way that they may or may not with parentage. Now, it's our goal to see everybody understands what that means for parentage as well. And I do not believe that a judgment of parentage is a lesser order. But here we want to provide people with options. Shortly after the election, I worked with the Pride Center of Vermont and Out in the Open to host a webinar on Vermont family legal security and the different paths to legal security. And we talked about the path through judgment of parentage, and we talked about the path through adoption. And even when the experts might say they have the same legal weight, people still feel comfortable, often still feel more comfortable pursuing adoption because they know it. And, and also they know that other states know it. They know that potentially when they travel internationally, they know it. And so having this is an option for people. It would then allow people to say, I want to choose a judgment of parentage, or I want to choose an adoption order. And it provides that option, at no cost to our system. If anything, it helps streamline. It takes those folks who said, I want the adoption instead of the judgment of parentage. They would potentially be doing that through our long, complicated process that ties up a bunch of resources as well. So here it provides that option in a streamlined way. And really the portability factor comes from right now, the current lay of the land and the knowledge of the understanding around what adoption is and what it means. And again, also we have the VLVEL case, which was a case in, I believe it was 2016. And in that case, there was the couple was in Alabama and they didn't want to recognize, they said we wouldn't have issued this adoption order. And the Supreme Court said, adoption orders are entitled to full faith and credit of the US Constitution. And so even though we know that full faith and credit applies to all validly issued court judgments, it is very easy to point to the specific case also and say, we know that it applies to adoptions, and people feel comfortable in that knowledge. And sometimes they often want to have that option to pursue that as well.
Sorry, what was that case again?
The VLVEL, and I can give you this.
I sent it to you.
Oh, you did? Okay, thank
Yeah.
you.
Yeah.
Thank you. Sure.
I just wanted to also just remind me what we talked about last week around the potential different treatment between an out of state jurisdiction looking at the statutes and acts of another state versus court decisions and the certainty that comes with the judicial orders of another state. Should be recognizing full faith and credit of the state's home acts, but there is some wiggle room there if it's against the other state's policy. So I don't know if you wanted to kind of address that, but I think it goes to kind of what the chair was talking about.
Yeah, I think it does as well. I mean, I recall from the previous conversation, I wasn't in the room, but I was observing and hearing, even questions about, we have marriage equality. So what does that mean for, like, shouldn't other states be recognizing children of the marriage? And I know you heard Attorney Crozier talk about how that has kind of not shaken out the way that we would hope it would in some states. We had the case in Oklahoma that I talked about, as well as Attorney Crozier. We had the case in Idaho, and even in Pennsylvania, there was this recent Supreme Court decision, which was fabulous. But prior to that Supreme Court decision, there was this conversation about the marriage presumption applied to intact family. And so when you have a family that's separating, suddenly you potentially lose from their policy position, lose some of those protections. And so, what we're doing here is we're making sure that there aren't any loopholes or gaps where Vermont children suddenly have increased vulnerability, right? We're trying to make sure that all families have a path to legal security that's easy to access, so that they do access it. Because we know that when there are barriers to access, when it is too difficult to obtain the protection, many people just don't. I think, that in Vermont here, we have the lovely benefit of being in a state with great, supportive, inclusive laws. But we also know, but we don't want that coupled with the difficulty to obtain an order to deter folks from getting the most protection that they can, particularly when we don't know what the future holds.
Thank you. Maybe any other questions?
Yes, good morning. Just a couple of questions here. I'll give you part A first. You had mentioned that other states don't recognize this process or whatever that may be. Can you give me the reason, or in your opinion, as to why, or
But other states, so
recognize this particular process, this particular bill?
Okay, so confirmatory adoption it's relatively new. We've got it so far in 9 other states that have been putting this process into place. Every state has the option for people who are married to one another to obtain a second parent or step parent adoption through their court system. That's a product of Obergefell v. Hodges from 2015, right? Is that this idea of you've got the marital presumption, so that way we have folks who are entitled to the constellation of benefits that come from marriage, meaning the ability to access adoption if you are married to the parent of a child, right? So we have step parent adoption in all 50 states. Second parent adoption or adoption for unmarried couples who've gone through this process, it's a more limited. There are 23 states now that have through their statutes a process for folks who are not married to obtain an adoption of their partner's child. That's very limiting. And then we have states that have a whole patchwork of variation on what their laws are around assisted reproduction. Some will say that a child born through assisted reproduction, the parents are automatically the parents of that child. Other states say, did you use a physician? Some states have, so there's a great variety of different laws as it comes to who is recognized as a parent of a child. What this bill does, it says, Vermont, we have already clarified who is a parent of a child here in Vermont. We know that if families go through assisted reproduction, they are parent of that child. We know that a donor is not a parent of the child. We know that if people are married, they're presumed to be parents. We know these things in Vermont, and this has been Vermont law for quite a while at this point in time. So what we're saying is that we are going to offer the people who are parents who are under Vermont law a path to make sure that they have something in their hands that they can take with them that says, I am not at the mercy of another state that doesn't recognize my family the way that Vermont does. So it's really just says, no matter what happens down the line, we have states that say we wouldn't have issued this order because you're not married, or we wouldn't have issued this order because of I don't know what. Now they have an order that says you have to recognize me as a parent to this child, and that's of great importance, and it's of great importance particularly to a child, right? If they come to a different state, say their family moves, and something happens, right? We don't want a child who's been with the only parents they've ever known to suddenly come to a situation where people are questioning who is or who's not that child's parent. So it's really important for stability and the well-being of children to make sure that those parent-child relationships are legally recognized, and adoption is a tried and true way to make sure that parent-child relationships are legally stable and recognized.
And part B of my question is, you see those 9 states who have passed this law. I would assume that, if any, are there any states that have tried to pass this law and haven't been successful in doing so?
So there are states in which it's pending right now. Similar laws are pending, but I am not aware of states where there's been this effort and it's been completely rejected or shut down. Perhaps Attorney Crozier does know of some of those, but if they exist, but I am not aware of any.
I just wanted to hop in and say I'm not aware of any in my experience, and I've worked on a number of these bills. They've been seen as like very straightforward, simple, but important tools for families and community members, and they've been a very positive and supportive measure. And just to share, in addition, so New Mexico did pass this session, and I believe bills are currently pending in New York and Illinois.
Great. Any further questions? Thank you. Next up, we have Jill Martin-Diaz.
Chair, committee members, to see you again. For the record, I'm Jill Martin-Diaz. I use they, them pronouns, and I'm the executive director of Vermont Asylum Assistance Project. We're a statewide legal services provider and technical assistance provider on all things immigration and compliance. I understand that I have been invited here today to speak specifically about the portion of the proposed combined bills between H98 and S95 that would codify court's jurisdiction over standby guardianship actions that Vermont Legal Aid has been taking leadership on in the last few months, as they did in the first Trump administration. So I might, because it's, I'm here to speak on a specific issue. I have some questions that have been posed to me through Vermont Legal Aid, specifically helping the committee understand what an adverse immigration action would be. But let me know if that's not a great place to start, because I value your time and want to make sure I get to the issue.
I think it could be helpful. Yeah.
Great. And was there anything else that you wanted me to address about the bigger bill?
I think it's just getting your general perspective, your opinion on the bill, if helpful, not helpful, or if you're neutral on it, and if there are any questions that the committee might have. Personally, I don't have any questions, but just want to hear your perspective.
Awesome. Thank you, Chair. So Vermont Asylum Assistance Project wholeheartedly testifies in support of this bill. As we saw with special immigrant juvenile status, which the committee passed into law in Act 98, I believe that was in 2019. The courts in Vermont are understandably reluctant to wade into areas that feel like they could be touching on areas of federal jurisdiction. And even though federal immigration law has made very clear the areas where the federal system will defer to the fact finding of the state courts, here again, we saw with special immigrant juvenile status that Vermont courts were reluctant to make factual findings regarding anything immigration without a really clear, clarifying jurisdictional statute. So they've looked to this committee to help them understand where their powers begin and end. And we've been encountering the same challenge here with standby guardianships. So standby guardianships are a mechanism used in almost half the states. I believe that 18 states right now have statutes on the books clarifying jurisdiction in state courts. to help mixed status families plan for the care and custody of their children in the event that they are incapacitated through an immigration enforcement action. Immigration enforcement actions happen in a lot of different ways. There's a lot of different scenarios where a person under the law might become detained or otherwise in custody by some sort of law enforcement and unable to communicate directly with their children, with their children's school teachers, with the friends and neighbors and family who are there as the support system for the child in the event of an emergency. And so this bill allows families to plan proactively now in times of calm, go to court, make plans, and do whatever that they can to prevent children's unnecessary custody in DCF. So that's the overview of we are wholeheartedly supportive of the bill. And what I can share about what we're seeing in the first 100 days of immigration enforcement, the different factual scenarios contemplated by this bill and its definition of adverse immigration consequences, all of those fact scenarios we've seen happening to the clients who call us for legal help. And we've received calls from legal help, not only from the people who are being detained themselves, who are seeking defense counsel in their removal proceedings, but even more often, like the first calls we receive are from the teachers in the school. We receive calls from friends and neighbors, from community groups, church groups, people, all the people that surround a family in their community to say, how can we help? How can we make sure that this child can be picked up from school, can have access to their meds, can be someone can sign off on their medical care, on their day-to-day choices for the duration of an immigrant parent's potential custody or detention or even temporary absence from the United States. What I understand from Vermont DCF, and I work in the committee, I don't want to speak on behalf of the department, but from what I would relay from of my conversations is that the department is very aligned in wanting to prevent unnecessary institutionalization of any kids of immigrant parents who become detained by immigration authorities. And the shortest way to do that is to help parents make a plan now. I'll pause there if there's any questions about who was considered.
I wonder if we can speak a little bit we've heard a lot from DCF about their inability to do anything more than they're already doing. So
Right.
There's this aspect as well. But I'm also curious about sort of the cultural context of taking a child out of a home in a family that may not be from the United States and placing them. There's been a lot of conversation, well, maybe not a lot, but certainly in my circles, social work community, about that sort of need to create cultural continuity, and the DCF system sort of overwhelmingly at times responding by placing children of color or children with different cultural needs in white families. And I just wonder if you can speak a little bit about that and what the impact of that is.
Certainly. Yeah. So we can kind of imagine if we don't have a clarification of court's jurisdiction to issue standby guardianships in Vermont, and judges continue to feel reluctant to help families plan, then what's the alternative is what you're describing, right? What we hear right now is people become detained, and oftentimes there's a gap in time between when ICE takes them and they show up in some facility somewhere in America, and we restore the ability to communicate with them. We fight with the facilities to, get access to our clients as the Constitution allows. It's quite a battle, and so there's quite a bit of time that could pass between when the parents picked up and when we get to talk to them again. And if there's no one to pick up the young person from school, the school systems who have called me a few times from the situation have no choice but to call DCF, right? If there's no other parent available to pick the person up. So now we have a young person whose parents are in these really high stakes proceedings, shrouded in secrecy. They're gone. They might share languages in common with their parents that are like the lingua franca of their home. And they're scared, and they also are watching the news and reading social media and understand that everyone in the country hates them, and now their parents are disappearing. So you have like the trauma of that point of interception. And then to what Senator Vohosky is describing, we already know, we have a lot of data, right, about the harms that impact children in institutional settings. The least restrictive setting is always going to be the most appropriate and least harmful for kids in care. And, you know, as Senator Vohosky points out, the young person who is part of a racial and linguistic and cultural minority here in Vermont, it would be, the harm would continue to flow if they found themselves in the care and custody of strangers who don't share their language and culture and religion and practices in common, especially if those families are already coming to us saying, we've already in our community worked out who we would feel comfortable with having custody of our child during the pendency of any proceedings. And that way, not only can we keep folks in community, but we can keep folks housed with people with whom they share language and culture during this incredibly terrifying, sensitive time in our history.
Any other questions from the?
When we went through the walkthrough of this bill, I had a question from the drafter just on what happens if the standby guardian is also detained in instance? Is there a way to have alternates, if you will?
Yeah, I'll let Vermont Legal Aid,
Okay.
Barbara Prime from the Disability Law Project has been the technician kind of thinking through some of those scenarios.
Yeah.
So I might, unless you want to jump in now, but if you want to wait for Barb.
Yeah, that's fine.
Yeah, that's great.
Yeah, we'll just wait. We'll get to him quick in a few moments here and then make a catch-up. I did have one question. I was looking at page 4 and, specifically regarding adverse immigration actions. Denial of admission or entry, at the bottom of the page, the denial or admission or entry into the US by the Department of Homeland Security. So the concern that I would have is if a family had been denied entry, but the child is placed with a standby guardian in the US, and then ICE shows up and says, well, the child was denied entry, so the child is going to go to some random facility, parents are just denied entry, and now they're separated. Can you provide some more clarity or thoughts on that?
Yeah, thank you for the question. The reality is that underdocumented children are, could be charged with removability and put through removal proceedings just the same as adults, right? And in fact, US immigration law, it contemplates children, even unaccompanied, unrepresented children, are supposed to be defending themselves in immigration court. I don't know if the committee is aware that as of last Friday night, we have the contract to provide universal rep for unaccompanied children in proceedings in Vermont, and the contract was canceled nationwide at the government's will was the cited reason. So not only did my organization lose over $130,000 of funding we used to pay for attorneys, there's 26,000 unaccompanied kids in proceedings right now nationwide who are expected to defend themselves against removal and assert their applications for humanitarian relief. So the system treats children cruelly, and it's immigration detention of children is pretty antithetical to everything else we understand about institutionalizing children. So it's against that backdrop that I warn. There are some scenarios that like our state laws probably can't prevent harm to kids. And if there was an underdocumented youth who's removable as charged and ICE decides to seek them out and to detain them, it is very likely that families will become separated because there are limited family detention centers. Family detention centers are problematic, so I'm not calling for more of them. This is a really harmful practice of incarceration that the Trump administration has revived in the last few weeks. But families will likely become separated. The thing that we see in practice, and that's just legally, right? The law allows ICE to detain youth, put them into the custody care of the Office of Refugee Resettlement. and have them in custody while they fight the proceedings. What we see in practice normatively is that immigration and customs enforcement is much more likely to pick up parents and pick up parents who have any kind of like recent citation, arrest, traffic infringement, criminal arrests, anything like this. And they'll be targeting a person for arrest under those circumstances. They'll usually pick them up outside of their home. They'll confirm their name and then arrest them. That way they don't need to present a judicial warrant to enter the home to make the arrest. And then typically the non-arrested parent and children are left behind in the community. We've seen a lot of these cases in the last few months. And ICE typically hasn't come back looking for the parent without the record and the kid who was in school. So I think it is possible that a child who is potentially removable as charged could become put on ICE's radar, and ICE could come looking to enforce removability on them. But with the legal tools that we have available to us, the immigration legal bar here in Vermont, we are seeing success. When we get involved in matters of detention, we are winning bond. Even yesterday, a Texas judge granted a Vermonter bond. It's an expensive bond. It's $15,000, but that person now gets to come home and fight their case with their family, and their family, ICE never kept looking for their family after their arrest. So I think our strategy is to help parents plan for that emergency situation so that immigration lawyers have time to intercede in the removal matter. And meanwhile, we know that the young person is covered. Once the government has made a decision to release a family on their own recognizance into the community to fight their removal proceedings from a non-detained posture, the government is not supposed to change their mind unless there's been a change in circumstances like an arrest.
Yeah, thank you. Any further questions? Okay. Thank you.
Thank you. If I may, just in closing, with regards to the definition of an adverse immigration action, I mean, I look at the subsections that are proposed here, A through F, and I think that I compared them to the language that's proposed in the other 18 states. And it looks comprehensive, and I think it's good to be clear with state courts about the scope of jurisdiction, because the courts are understandably reticent to overreach and get involved in any immigration stuff, especially now.
Did you say this exists in 18 other states?
Not this exact language, no, but a standby guardianship bill analog. And states have different approaches. There isn't like an overwhelming consensus, which makes sense since family guardianship law is so particularized with states. One thing I'll say, so I would advocate for an expansive but drawn out, explained definition like what you have here. And I especially appreciate in subsection A, where in subsection B, where you talk about any federal law enforcement who may or may not have been deputized by the Department of Homeland Security. A practice we're seeing here in Vermont by virtue of our border location that I want to make the committee aware of are that when the Department of Homeland Security is short on resources or beds, what we are seeing is an uptick in Department of Justice prosecutions of immigration-related criminal statutes. So there are a number of non-citizens in Vermont who, by virtue of living close to the border, are vulnerable to being put through the criminal system. And we're in touch with the federal defender bar, and we understand that there are a lot of non-citizens who are struggling to get immigration advice in time for the federal court pleadings. That's something else we're working on. But I want to draw the committee's attention to the reality that there are immigrant families who are facing enforcement not just by DHS officers, but also by federal law enforcement here in Vermont. Thank you.
So who did the walkthrough on this night? I missed it, obviously. Eric, or I just have a couple of questions over here.
Great. And we want to make sure Brian has plenty of time to testify as well. And then we'll have to go to
Thank you so much, everyone. My name's Barbara Prine. I'm a staff attorney at Vermont Legal Aid, and my colleague Alicia Roderick and I developed this program in response to the need. I want to talk to you about what the need is, how we're working to solve the problem, and the statute, and just a couple of tweaks that I need with the statute. So the problem is, as Joe Martin Diaz described, if parents are picked up by immigration authorities and the children are not picked up, either because the children are U.S. citizens or because the children aren't with the parents at the time, the children would go into DCF custody, and DCF does not have a way to reunite children with their parents in Guatemala or Mexico or Ecuador. They can't do a home study. So those children would stay in DCF custody. If the parents are deported, the children would stay in DCF custody until they're 18. Nobody wants that. Parents don't want that. DCF doesn't want that. Mom doesn't want that. DCF doesn't want to take kids where there's another plan, a good plan. So we have worked with our local community to help parents develop good plans, and we have trained volunteer attorneys to meet with these parents and set up standby guardianships. So we've trained 25 attorneys. We have 20 active attorneys around the state who will meet with families through power of attorneys forms, fill out guardianship forms, fill out the consent to have a minor guardian, do all those forms now. We've had 3 clinics. We've helped 35 families. We have 23 families more waiting for help. Where we do this paperwork, the lawyer keeps the paperwork. If the parent is detained, then the lawyer goes to court and files the paperwork with the guardian to set up the temporary guardianship. So all the work is done ahead of time, is held, and then if bad things happen, it's filed then. To answer your question, at this point, we're telling people that we don't recommend that they have someone who does not have legal status here as their minor guardian, because courts aren't safe places for those parents to go to for file. If I'm undocumented and you're my brother and you're undocumented and I ask you to take my kids, you would have to go to court as the guardian, and that's not safe for you. So we're recommending that people not do that. And that they find someone. The biggest barrier to this program, honestly, is for parents finding someone who is willing to do this. Because it's hard to, some of these communities are pretty isolated. The farm workers communities have more connections than the people who are working in construction and in restaurant work. They tend to have been here less long and not know someone who would be willing to take their kids for the weeks or months that they're held. So that's sort of the situation. Most of the families we've helped so far are Chittenden, Addison, Franklin counties, but some in Orleans and Bennington and Rutland, and that's how the program's working so far. So that's the general picture and the need. I think the guardianship law contemplates this happening now as it is, because the guardianship law is to protect children and to bring them permanency and support from trusted adults. But not all the judges agree with me. And some of the judges want a clear description that they're allowed to do this, that they're allowed to take paperwork that was written at a clinic in Burlington, Vermont in February and file it in July, in months later when the parent's detained, that there is a clear path to a standby guardianship. So I like to make judges happy. And so we want to have the clear path that describes this process. And so that's why we wrote the law that, and, but I also think that, that it's clear that parents are allowed to identify people to care for their children. Guardianship law for minor guardians is often used when parents are incarcerated or when they go into drug treatment or when they have medical problems. So this is just expanding when a parent can designate someone to, and describing when a first parent can designate, I wouldn't say expanding, describing when a parent can designate someone else to care for their child. So I want to answer questions and I want to just talk about a couple places that we're seeking edits, but first, I want to make sure you guys get a chance to ask your questions.
Any questions?
So identifying places, you pull out the legislation. The first place is on page 3. And it's lines 3 through 8. And basically it says, it defines custodial parents. And what we're finding is a lot of parents don't have custodial parentage orders because they can't go to court to get a custodial parent order because courts aren't safe places to go. So parents say, I haven't seen the father, he went back to Mexico, or the father stayed in Florida when we were working there. It's those kinds of situations where there's been separation between two working parents. It's not always the mother, it's actually often still the father who has the kids. Sometimes is that in 2 cases, it's that one parent has been picked up by ICE and the other parent hasn't. So we can't really have a definition of custodial parent. So when I met with Judge Zone and Teresa Corsums, they suggested that we just edit out that whole section B and take it out. So that's one request. And then, and I submitted this with my testimony. The other two is on page 9. Section A at the top, lines 5 through 7, Judge Zone, and believe that the consent sentence is not necessary. The consent shall provide that the custodial parent's agreement is contingent upon the parent becoming subject to an adverse immigration action. Did not feel like that was necessary. And then at the bottom of the page, on page 6, on line 16, instead of saying that the parents intend to create a standby guardianship, it should say that the parents are creating a standby guardianship. But we're having the parents fill out a form saying, I consent that if I am reported, Senator Baruch can raise my children, and he is agreeing, he's also signing a paper that he agrees to care for my children until me and my children can be reunited in this country or another. That is what the document is saying that we're signing now at the clinic. And then that gets filed later on if I'm deported, and then we got the kids. Yeah, it's very kind.
Sorry, now that they're mine, I have a question.
But they're only agreed until they can be reunited. So
Right. So that's where my question comes in. So the standby guardianship is until they are reunited.
Until they can be reunited, yes.
What does can be reunited mean?
Well, see, this is the problem, right? It's what Jill Martin Diaz talked about. If someone, you don't know if someone's going to be in custody for 6 weeks or 6 months. You don't know if they're going to be released in Texas or in New York, and you don't know if they're going to be deported. So
But if I could jump to the
Yeah.
chase, so let's say they are reunited in another country.
Yeah.
How is the mechanism of my standby guardianship ended? What's the formal mechanism?
So the formal mechanism would be that the parents and the guardian would file a paper in court that says that Barb and her children have been reunited in Ecuador on September 28th, 2025.
Signed by those parties.
Signed by those parties,
Yeah.
yeah.
Okay,
Yeah.
great. Thank you.
Yeah.
Any other questions? Well, thank you for your time. I think I'm sorry, did you have,
No, I mean, I appreciate you doing this. I appreciate the volunteer lawyers who are working with us. And I appreciate Eric's work to do this so quickly and your work to take it up and figure out how to move forward.
And we'll definitely be revisiting this. We're unfortunately pressed on time today, so we'll
Yeah.
get some more questions from us in the near future. But
Yeah.
yeah, thank you for coming in.
Okay, thank you very much.
Here's to H105. Well, I have you at the top of the list.
Yeah.
Is it easier for you to go first, or do you want Beth to go first to walk through the bill?
What do you think, Ben?
I mean, if you want to say about why, so
Okay,
like this,
Sure.
you know, the problems that.
Yeah.
I think that would.
okay.
You could start.
Then
with-
you could,
Yeah.
go I will.
Okay, great.
Yeah, no, she's gonna kind of set the stage in their problems and so address it. Just help.
Great.
Thank you.
Just bow there. Good morning. For the record, my name is Willa Farrell. I work at the Attorney General's office. And my title is Court Diversion Pretrial Services Director. And I'm here today to speak in support of H105. In short, this bill will expand the Youth Substance Awareness Safety Program. That's a program that operates under the umbrella of the AGO and our court diversion programs, which we fund 12 organizations who provide these services statewide. Currently, when it comes to the violations that are addressed in this bill, namely underage possession of alcohol by young people and driving blood alcohol content of 0.02 or less, we have what I call a bifurcated response in the state that is confusing to people underage drivers, underage youth who possess alcohol. And their parents, and also frankly, many people within the criminal and legal system. So what's proposed in this bill would lead to a faster intervention with youth. I think it would hold youth accountable for their behavior more quickly. And it would allow for more timely connection to support services for youth. Really furthering what I see as two goals: public health of young people and public safety. It also avoids unintended consequences, collateral consequences that happen through the current system. There are two sections of the bill, and I think that LaCrosse will go through the details, but I'll speak in broader terms to what are the two components. So the first is possession of alcohol by youth under age 16. Currently, that's a delinquency violation, not a crime, but it's a delinquency. Struggle over how to make that. This bill would make that a civil violation and align the process with what happens when somebody's 17 or 19 is caught by law enforcement with alcohol. Currently, the problem we're trying to resolve here is in the current situation, law enforcement have the right out of a delinquency petition, file it in the court. First, it goes to the state's attorney. Sometimes in a large gathering with who might be 15, 16, 17 to 18, law enforcement have multiple roles, paperwork to be filled out. Sometimes officers issue a ticket inadvertently to a younger youth because they may not be clear what their age is. So our staff then go back to the officer and say, please issue this as an emergency petition. Sometimes that happens, sometimes that paperwork falls by the wayside. So we had varying responses happening statewide. In some counties, state's attorneys are telling law enforcement, just refer these pre-charge. Other places, when they get a delinquency petition, it's referred directly to diversion. So the intervention when a youth comes to diversion is very similar as if they were referred to a civil violation. And we do a web-based screening tool to assess risk about substance use. There's an educational intervention based on that use risks of how they use substances. And for kids who are at higher risk, they're referred to a counselor and they're required to engage in treatment in order to be programs. So programmatically, this bill wouldn't change much, but what would happen is the process would happen more quickly. Law enforcement would refer directly to the program as opposed to the multiple variations of what's happening statewide. So that's in a nutshell, that section of the bill. I would suggest an addition that Senate Judiciary consider, which is to add possession of cannabis. So this came up very late in the House discussion. Currently, you who possess a small amount of cannabis who are under 60 have the same delinquency petition process as this bill seeks to change. We also work very similarly for older youth who are referred to the youth substance awareness safety program, whether it's alcohol and cannabis. So I think it would be a simplified process to include cannabis as well as alcohol as a civil violation. That's one section of the bill. The other component of the bill was really expand the youth substance safety program are the addition of 0.02 violations, which are civil violations. And so these are violations by youth under age 21 who drive under the influence and whose blood alcohol content is 0.02 or less. Currently, law enforcement issued a civil ticket, and I brought a copy. It's a voided one, but just to demonstrate on this ticket, the waiver amount is $47. So youth often see this ticket and think, oh, I paid $47 and that's all I need to do. They may not understand or remember that that also comes with a license suspension, and that in order to gain their driver's license, they need to complete IDRP, which is Impaired Drivers Rehabilitation Program, which is operated by the Department of Health providers. So sometimes you see these tickets and they also get a notice of violation for possession of alcohol. So this is how it's become known to programs that we've got, that kids and their parents don't necessarily understand the ramifications of this ticket. And probably even more significant to my way of thinking is that there's not necessarily an intervention. If they only get this 0.02 ticket and they pay the fine, then get a notice that license is suspended, which they may or may not really understand, and not engage in IDRP. It's a time intensive process that delays every intervention. So you really may have a problem with driving. So what is suggested in this bill is to include these violations as an option for youth to be referred to by SAS. So they would be given a similar notice of violation as happens now if they just had alcohol. They would also face a license suspension if they engage in the program and complete the program successfully. That license suspension would be shorter than if they failed the program. So the consequences to the youth are similar to, as proposed in this bill, to what is current law, but it would happen more quickly, and youth would be referred, plus our staff reach out to youth and help them understand and navigate the system. Last year, there were about 40 of these tickets adjudicated through the Judicial Bureau, so we're not talking a large number of youth, but I think it's a significant group of kids around whom we have concerns. I want to make sure that they are seeing get support quickly. I guess I would add that if .02 tickets are added to the YSAS program, we'd be working on refining our guidelines. We would have a different intervention for youth referred. We would still be doing the screening and the brief intervention. But I have had, for example, conversations with Dennis Waits from the Department of State's attorneys about different screening tools that really focus on driving. Then I just know that if the youth fails the program or never engages in the program, there would be a longer license suspension and a larger fine that is what is currently a law. So it would be $300 fine. Our engagement in YSAS was voluntary, but there would be these incentives of a shorter license suspension and avoidance of the $300 fine. So that's my overview of.
So Bruce, just a couple of questions. I'm looking on page 2, and one for me triggers is attempt to operate actual physical control. So I'm trying to think of how operate differs from actual physical control.
This, Ben may speak to this. This language is in current law.
Even so, I'm wondering.
Yes. So my understanding is, and I'm no expert, if you could tell you this, but I think if you are parked by the side of a highway and you're at the wheel, you're considered to be in control, even though you're not.
I see.
Driving the vehicle.
Understood. And then my second question is, I'm looking at this is now applying to 12-year-olds.
Yes. Yes.
So I'm thinking a 12-year-old operating a vehicle with any alcohol. It's hard for me to imagine, but we're saying it's okay if they have less than 0.02. And I'm wondering why that.
Well, the 0.02 threshold is long-standing in the law. I think what I've heard law enforcement and others testify is if this is one tool, it doesn't preclude other interventions. So if somebody's behavior in driving the vehicle is problematic, that can be a reason. And the other thing, more to your point about age. Frankly, if we were going to see the youth who was 13, we would be contacting CF, and there are other mechanisms within for law enforcement. If they were to encounter a very young child in substances, anything.
And I think there's another piece also, impaired to the slightest degree.
Yes.
So, that gets to the person who, if they're at a 0.07, they're technically below the threshold, but if they're a super lightweight and very drunk and still driving, the DUI law would still apply to them. So.
Yeah, it's just, I just think it's a little striking. If we went to 0, what there being unintended consequences there?
I'm sure, in life, there probably, just to answer you directly, there probably would be unintended consequences. What those are, I am not sure. I think probably law enforcement would be better. Somebody from law enforcement can speak more clearly about how measurement of blood alcohol factors into enforcement of these laws.
And I guess I've said this before, but
Yes.
in Sweden, they have 0 standard.
Yes.
And so even people who were drunk last night can be arrested in the morning if their blood isn't fully clear of the alcohol. And that's just the way their system operates. I think here, when we're talking about adults, we tend to want to say, well, you can have 1 drink, but you can have 2 drinks. But if we're talking about minors, they shouldn't have any alcohol in their system. And so it just seems odd that we would ramp down the age,
Yes,
but still say it's okay to have 0.01.
Yeah.
Up
No,
to
I-
0.02.
I think you made very valid points and personally, I think because you say no one should have to that level when they're underage. And I do know that the zero tolerance, there's an argument for that. I have heard Dennis Wigman speak a lot about how 0.08 and 0.02 came to be sort of the standards. I mean, it sounds like it was being matter of compromise, maybe not always based in science.
Yeah. Based on the committee.
So that number is one of those things that they were going back and forth between 0.04 or 0.0 and randomly landed on 0.2 right now. Thank you. Thank you. Thank you. So then with 10 minutes left, do you want to give a general overview or maybe for that?
I can probably have a speed through general overview and, you know, we want to get more details. By year.
Yeah, that sounds good. Let's,
So I'll avoid sort of the line by line.
Yeah.
I'll just, okay. Morning committee, staff. For the record, Ben Obrodsky from the Office of Legislative Counsel, back with another impaired driving bill for the committee's consideration. So I will avoid sharing my screen for the time being and just kind of make references throughout. But Will and me, gave a great overview of sort of what this bill attempts to address as far as the problems and confusions, but essentially it's doing three overarching things. One, converting impaired driving violations for those under 21 years of age, provide that 0.02 breath sample to a civil violation rather than a delinquency. It requires those underage 0.02 violators to enroll in the YSAS program. And three, including those 12 years of age or older who commit violations related to alcohol procurement, consumption, possession, or impaired driving into the YSAS program. So Section 1 amends 7 VSA 656. You'll see on line 6, page 12, the change to 12 years. It adds impaired driving to the list of prohibited conduct. That is embodied in the addition of section A1B. You attempt to operate, or be in actual physical control. Again, Will and David kind of good example of what to be in actual physical control is. You'll see subdivision 2 of that subsection retitled to now highlight the procurement, possession, or consumption penalties. It clarifies that it's a civil violation under the jurisdiction of the Judicial Bureau. It keeps the penalties the same for those violations. That remains unchanged. However, you'll see on page 3 the addition of subdivision 3. And this portion really rolls in 23 VSA 1216 into this statute and outlines those impaired driving penalties. So if you violate this portion of the law, you're referred to court diversion for purpose of enrolling in YSAS. And you also have to serve that smaller or reduced term suspension. If you fail to complete that program, then you're referred to the Judicial Bureau for a civil penalty. And you'll see subdivisions 1, 2, and 3 outline what those penalties can be. For a first offense, a civil penalty of $300 and a suspension of the person's license for a period of 180 days and compliance with the requirements of 23 VSA section 1201. That's essentially the reinstatement provisions to get your license or permit back. For a second or subsequent offense, $600, a license suspension of 1 year, or until the person reaches 21 years of age, whichever is longer, and in compliance with those reinstatement provisions. And then, three, someone who, you may also be able to lose your license if you have a provisional license, so either junior operators or a learner's permit. That's current law, so it just reiterates that.
What if you're 14 and you get pulled over for impaired driving? You don't have a license to suspend.
Right. Well, it can also preclude you from getting one.
Okay.
And then also that, as Will was saying, there are all these other sort of rehabilitative aspects. That's part of the goal of, I guess, for the lack of a better term, the sanctions related to the penalties. You have, scrolling on down, the rest of these sections on page 4 are really just rolled in. They mirror those 1216 provisions, so there's no change in the law there. You'll see that suspensions that run concurrently you can receive credit for one against the other. A violation of this section, and this goes to the point that was being talked before, does not preclude the prosecution for something else. So that's impaired to the slightest degree. It can still allow for that. It can allow for other interventions with DCF. So it's not exclusive of those remedies. You'll also see scrolling down again, was going through the crediting to the suspensions. You can also apply for a restricted driver's license during this. There's a process for that. Again, current law, but just rolled into this. The way this would go is normally you receive a notice of violation. This makes it clear in subsection B that someone who is cited for one violation of the subsection, so possession, consumption, procurement, or impaired, the prosecutor or the law enforcement officer has to pick one. That way there's no sort of dueling requirements where a person can get confused for completing one but not for the others. You'll also see in a new subsection C added, which is an issuance of a notice of suspension. This is similar to what occurs in the civil suspension procedure under 1205. This is a new provision here to give those impaired drivers notice that their license is going to be suspended in a short time, and here are the consequences. So, on behalf of the Commissioner of Motor Vehicles, law enforcement issues this notice, and it includes the effective date of the suspension, the suspension's duration, explanation of the consequences of the suspension, explanation of the process to operate a motor vehicle with a restricted driver's license, the projected date of reinstatement upon successful completion. It's an estimate because maybe you don't complete. And then a suspension issued pursuant to this shall become effective on the 11th day again after the person receives that notice. Again, that's right out of section 1205. And then a copy of this notice is also sent to the Commissioner of Motor Vehicles so that the department has the information necessary to actually suspend the license if it gets to that point. Outside of that, just the technical corrections flowing down from there. And then you'll see in subdivision, or rather in subsection H, the addition of some confidentiality in public records, exemption language. And also you'll see on the top of page 13 that one of the entities that can receive notice, so where confidentiality doesn't apply, is an insurance company or its contractor, basically for purposes of recording the license suspension for them to calculate their premiums that they like to levy upon us. You'll also see that subdivision 2, this goes through the confidentiality and public records. Essentially, they're exempt from public records. Request the records that are associated with these violations. And then there's a reporting requirement that beginning annually on October 1st of 26, the AG's office and other entities as needed submit a report to the House and Senate Committees on Judiciary related to impaired driver violations. Basically, House Judiciary was interested in knowing how often these violations occur, how frequently, all of that. So this would record the number of persons referred to YSAS, the age of the persons referred to the program, number of persons who successfully complete it, number of persons who fail it, and the number of people who serve suspensions that are imposed by the Judicial Bureau. So ones, not the ones that just automatically go into effect, the ones that are imposed because you failed the YSAS program. Section 2 creates an outcome measures report. So for the first report that I just described, the AG's office, in addition with CRG, otherwise known as the Vermont Statistical Analysis Center, and others, shall propose outcome measures to assess the effectiveness of any suspensions imposed for impaired driving violations and the YSAS program as a whole. This portion of the bill came out of, there was, I would say, substantial discussion in House Judiciary about what the length of that of suspension should be for impaired driving violations. And whether there's information or evidence to support that a certain length of time yields better behavior after or not. So section 2 is aimed to provide those answers, to create those outcome measures to help assess the effectiveness of these suspensions. You'll see section 3 just strikes a reference to 1216. It's no longer needed as that's being repealed and rolled into section 1. And then you'll see section 4 that it is being in fact repealed, and then also the delinquency statute for 657A, because we are no longer treating these violations as delinquencies but as civil violations. And then section 5 of the bill is the effective date, which is July 1st of this year.
Thank you. Committee, any questions?
Probably, but we're out of time.
Yes.
I did it right on the nose. So.
Yeah. Okay, well, I'm sure we'll have you back for a more detailed walkthrough and some markup probably. But yeah, thanks for the general overview of it.
If there are any questions between now and with all your free time.